Okay, so good afternoon, everyone. As Liz said, I'm Britt Burner, and we're here today to talk about the duties of an administrator and executor. A lot of the things that I'm going to be talking about today will also be similar duties to that of a trustee of a trust after someone has passed. However, we're not specifically going to be talking about the trustee today, but there is some overlap, and we can get to that in another session. But for today, we're talking about administrators and executors. So I think it's very important to explain what the difference is between an administrator and an executor. So if somebody has a last will and testament and they die with assets in their sole name with no beneficiary, those assets must pass through a process called probate. Probate is the process by which the court validates that will and says, yes, this is an appropriate will. Deals with anybody who might be contesting that will, anyone who's going to come in and say that that's not actually their will, that's not their signature, or that is their signature, but they were forced to sign it, and this is all the reasons why I think this isn't valid. And at the end of the probate process, the executor gets appointed through what are called letters testamentary. When the decree is signed by the court and the letters testamentary are issued, that's what makes an executor the official representative of the estate. The administrator, similarly, is someone who is appointed through a similar court process. However, that is usually when there is no last will and testament. So if somebody if someone dies again with assets in their sole name with no beneficiary, then those assets, and they don't have a will, then those assets need to go through the administration process, which again looks very similar in the courts. And at the end of that, an administrator is appointed, and those letters of administration are issued with the decree, and that person then becomes the legal representative of the estate. So important to realize is that even though a will is written and it has an executor's name in that document, that is a nominated executor until the person becomes an appointed executor by the court. And a nominated executor does not have power. So what would happen? If you have a bank account and you die and you are the only name on that bank account, then if the nominated executor under that will takes the will and goes to the bank and tries to access that money, they're going to be told by the bank that they need to get letters testamentary from the court, which means the probate process must be dealt with. So that's a very important thing to realize right off the bat. That's what an administrator is, and that's what an executor is. The next important thing to talk about is who can serve as these functions. This person must be a U.S. citizen. So this is important. If the only time that a non-U.S. citizen is able to serve and is appointed by the court as administrator or executor is if they are a green card holder in the United States. But in those cases, the court is going to require that a New York resident be appointed as co-fiduciary with the executor or administrator. I'm going to use the word fiduciary when I'm referring to both executor and administrator. The fiduciary is the person appointed to be the representative of the estate, and it will apply to both administrators and executors. They are both types of fiduciaries. So when you file for probate or file for administration, the job of the person who's hoping to be administrator or executor is to actually make that filing. Now, usually what happens is somebody who is looking to deal with an estate will go to a lawyer, and quite often the lawyer will draft up a petition to the court for administration or for probate. The original will, if there is one, without the staples removed from it, along with a petition and other documents that the court requires, will be submitted to the court, and that is the being entered for probate. So that is the nominated executor asking the court to approve that will. Once all of those documents are submitted properly and the proper people are notified, that's when letters issue. Now, the first job often for this fiduciary is to determine who has to be notified. So in both the administration and the probate proceedings, the next of kin need to be notified for the individual who passed. And this can be difficult, as we've talked about in prior seminars, if the next of kin are either being disinherited or if they're long lost next of kin. So our best example was a time where someone had a will, and their will named two friends as co-executors and co-beneficiaries. But when the next of kin had to be notified upon this person's death, we realized that they were an unmarried person with no children. They had no living parents. They were an only child, so they had no siblings. Their parents' siblings were long deceased. So our best guess was that there might be a first cousin alive somewhere along the way. But both of this person's parents were born outside of the United States, and this person was born outside of the United States. And so the idea of trying to find where these next of kin lived or who they were was very difficult. And the nominated executors through our law firm had to hire a genealogist to determine who the next of kin were likely to be and where they were likely to be living, so that when we couldn't find their exact locations, we could publish in newspapers nearby where they live so that they can have official notice according to the court, and the court can be satisfied that we attempted to notify the next of kin so that the probate process could continue. So very often the first job for that administrator or executor is to determine who these people are so that the process can continue. The other very difficult thing that we're often contacted about is what happens when someone passes away before this process is completed, before there's officially an executor or an administrator appointed, and the nominated person or the person who wants to step forward and act wants to go into the residence and start cleaning it out or look for things. What happens? And a lot of different factors go into what the answer is going to be to that question. A few of them are, was it an apartment or was it a freestanding home? If it is also another question is, did the person pass away in their home and were removed and the police were involved, or did they pass away outside of their home in a facility or otherwise? When someone passes away in their home, very often, especially if they're alone, the police are going to seal that apartment after the body is removed, in which case there needs to be an unsealing of the apartment once the official person is nominated or is appointed to the estate. If you think of it this way, if I were to pass away in my apartment and anybody could go in, and there was a dispute over who the executor was going to be of my estate, or a dispute over the validity of my will, then you wouldn't want somebody entering the apartment and removing things that might not be their own. So somebody has to be officially appointed for the police to allow the unsealing of the apartment. You also want to deal with the fact that if you're the executor who is nominated, until you're appointed, you want to make sure that, again, nothing leaves the home, because you don't want any liability for the fact that you've allowed others into the home or you've taken things out of the home before it was time to do so. And so you want to make sure that you're properly preserving the assets of the estate. Very often, the court will set a bond in an administration proceeding. So if somebody has bank accounts worth $300,000, the court will set a bond, which is security, and then there will be premium payments that need to be made to the bonding agent, to the surety, in order for that to be done. Very often in a last will and testament, the issuance of a bond is waived, and that is not a necessary expense of the estate. So it's important for an administrator or executor to figure out if there is a bond on the estate and how that bond is going to be paid through trust assets. Another thing that's very important, and I'm jumping ahead on this one because of how important it is for the person who is appointed to the estate, the administrator or the executor, to determine what taxes are owed on behalf of the estate. If estate taxes are owed, estate taxes are due 9 months from date of death. So it's very important that things get moving quickly if there are estate taxes owed, because you need to make sure that the assets are freed from the estate to be free for the estate to pay the taxes if applicable, and also that there's liquidity. If there are estate taxes due and there's no liquidity in the estate, the executor or the administrator is going to have to do something to create that liquidity. And so you want to make sure that if it is going to be a taxable estate, that the fiduciary is acting quickly to be appointed. In terms of the last tax returns for the year in which the person died or the prior year, again, once there's somebody appointed to the estate, that person can sign those last tax returns and settle any tax debts on behalf of the deceased person. Once appointed, the executor can then accept and collect all of the assets of the estate. These may be bank accounts, checking, savings, CDs, anything, again, that is in the deceased person's sole name with no beneficiary. So if there was an IRA, for example, that had a beneficiary named as on the account, that beneficiary on their own can contact the institution that holds the IRA and learn their options for distribution of that account. That is not a job of the executor administrator if there's a beneficiary named. However, if the beneficiary that's named on an account, any type of account, is the estate of the deceased person, or if it has no beneficiary, then that is going to be a job of the executor or administrator. An important thing to realize is that while you are allowed to be a non-New York resident and be the executor or an administrator of an estate, if a bank account has to be opened, it does have to be opened in the state of New York. And so that is something that's important to realize, that it needs to be a New York domiciled bank account. So if you are a Florida resident who is going to be the executor of an estate for somebody in New York, that account's going to have to be opened through a New York bank, not a Florida branch. And so that's something that you're going to have to coordinate how to do that once you are appointed. You, once you're appointed and you decide you're going to go in and clean out the residence, whether a rental or a property that the deceased person owned, again, as the fiduciary for the estate, you have the responsibility to collect those assets, be it the couch, the furniture, the jewelry, whatever it is, and preserve those assets for whoever the person is that they are to be distributed to. In some cases of a will, there'll be specific pieces of property that are referred to in the will that go to a specific beneficiary. So for example, I give my engagement ring to my daughter, I give my antique chest to my son, I give all of my clothing to my best friend, whatever it may be. In other cases, and even in those cases, it may say all the rest of my property is to be sold and distributed as part of my residuary estate. Or if there is no one to give the property to, it can be distributed that way. Or it may say all of the rest of my personal property can be divided equally amongst my grandchildren. Whatever it may be, that's what the nominated and then appointed person is going to have to do with those assets, and they are responsible for that. In terms of documentation in the home, we generally recommend that a birth certificate, a social security card, a marriage license, a divorce decree, that these items are kept. We don't recommend these be destroyed because they're items that are very difficult to replace. In terms of old income tax returns, bank statements, and other financial records, we recommend that those be kept for 7 years. I'll say about bank statements, people often have to remember that if it is a 6-page bank statement that seemingly only has information on one of the pages, it's still important that you keep all 6 pages. So you want to keep the entire statement. Now, you can keep them electronically if you have a reliable system, but one way or the other, you want to be able to access those in case something should come up in the future. The next thing the nominated or the appointed person will have to do is pay all of the debts of the estate. So people ask me all the time, my loved one passed away and they had a ton of credit card debt and barely any money. Am I going to be stuck paying that debt? The answer is no. You're only responsible to pay debts to the extent of the estate. So if somebody has debts, the beneficiaries or the children or will not be responsible on their own for that debt. It's different with spouses, and so that's going to be a more nuanced answer. But in terms of other beneficiaries, you are not going to have to worry about that debt. Administration costs of the estate and funeral bills are priority claims. So those claims get paid right off the top of the estate before anything else goes out. If it's what we call an insolvent estate, so there are no ways, there's no money in the estate to pay the debts of the estate, then usually we'll have to have a proceeding to have judicial approval to close out that estate to make it clear that there is no money to pay those creditors. You want to make sure that once appointed, you give enough time for creditors to come forward, because you don't want to be dealing with claims after you've distributed money from creditors that didn't come forward. There is a 7-month creditor period from the point at which somebody is appointed from when the letters of administration or the letters testamentary issue. So for those 7 months after appointment, there shouldn't be distributions that are going to exceed or not leave enough in the estate for debts that are unknown. So exactly what to do about that 7-month creditor period is going to be something that you need advice on for case-by-case basis of how to make those distributions. But you don't want to be making distributions out of the estate accounts when you believe that there might be creditors coming in, because you can't get that money back very often, because those beneficiaries may not want to let it go once they have it in their hands. So you want to really make sure that you have enough in the estate to pay the debts that are going to have to be paid. So during that 7 months, a creditor can make a claim, and then you as the executor administrator have the ability to reject that claim. So for example, if a claim is put in for a debt that you don't think is valid because there's no documentary evidence, or it was a service that wasn't completed, or whatever it may be, just like when you're going through your own bills and you decide what bills you're going to dispute and what bills you're going to move forward and pay, you have the right to do that as the fiduciary of the estate. And then if you reject a claim, that person or that creditor can put in paperwork with the court for a proceeding to fight that, and the court will make a decision as to whether that claim should be allowed or not. You want to realize that if you know of a creditor and they do not come forward during that 7 months, and then as fiduciary, you distribute out that estate completely and there is no money to pay that creditor, you can have personal liability. So I'll give an example of that. If you know that your loved one was living in a nursing facility and there was a bill at that facility, or you know that that person was on Medicaid and there was a Medicaid bill for monies owed, monies paid out by Medicaid on behalf of that person, and you know that this existed because maybe you were power of attorney during life or just involved in some other way, and that bill is a bill that's owed, and you don't say anything, and the 7 months goes by, and the money is all distributed out by you out of the estate to the beneficiaries, and then the creditor comes back in months 8, 9, 10, maybe over a year later and says, we are owed money for this bill, and that executor knew about it from when the person was alive, that can create personal liability. So you want to make sure if you know of any claims that you seek out that bill and pay it, or determine whether or not it should be paid, because you can have personal liability in that situation. The next duty I'm going to talk about is an accounting. So just how formal the accounting is going to have to be is going to depend on the situation. In some circumstances, it's very easy for the executor to send, if there was one estate bank account, they can send the bank statements from that estate bank account for the time they were executor. And if all the beneficiaries agree that there was nothing that looks strange, they will sign what we call receipt and releases, which will release the fiduciary from any liability going forward, and then the beneficiary can receive their distribution. In other cases, it may be something a little more formal, like a QuickBooks accounting. And then further, there's a formal accounting, which is in the case of a judicial accounting. So especially in contested matters, or very often when a charity is the beneficiary, we're going to make sure that we do in most cases where the charity is a beneficiary, we're going to do a judicial accounting, because if a charity is beneficiary, the Attorney General of the state of New York is involved. And so you want to make sure that they are satisfied with your job so that you can be released and the charity can receive their distribution. And then once the court gives the sign off in that judicial accounting, then the assets are distributed. So again, if you're doing an informal accounting, certainly you're going to want receipt and releases from those beneficiaries to make sure they don't come back later and say that as trustee, you mismanaged the money, or sorry, as executor or administrator, you mismanaged the money in any way or anything like that. And then the distribution is made. And I know we had some questions in advance of the topic today about how distributions are made and how assets are distributed. If the assets are in the estate and they have to go out to the beneficiaries, exactly how it's done is going to depend on the type of asset. If it's a bank account, a checking account, then a check will be written for that beneficiary share. If it is a piece of real estate, there will be a deed from an executor's deed where the executor signs and transfers the property over to the new owners pursuant to the terms of the will. If it is any other asset, it's just going to depend on how that asset is owned. If it's a car, the title of the car can be turned over to the beneficiary, and that can be done through the DMV. So every asset, however you title that asset, the asset name will be changed to the new owner who took it in as beneficiary. I think we have a question, Liz, if you want to ask that.
Yes, we do. I am the executor of my father's estate. The only heirs are my 3 siblings and me. We have distributed the assets evenly. Do we need to have everyone sign a waiver and consent?
So a waiver and consent is actually different than the receipt and release that I was just talking about. The waiver is usually something that's signed by the next of kin at the beginning of the process, so that they are saying that they're waiving any objection to the will being admitted to probate and waiving any objection to that executor being named as executor. So that's what the waiver and consent is. They're consenting to the will being admitted to probate. But a receipt and release, I mean, generally speaking, an executor is going to want the receipt and release to be signed by the beneficiaries, because they're not going to want anybody to come back later and say that there were any issues. However, if the assets are already distributed, you could seek for the beneficiaries to sign those receipt and releases, but they may want some type of accounting. Is there another question, Liz?
Yes, next question. Do state taxes come off the top, that is before distributions are made?
Yes, so the taxes will come off the top of the estate. All debts of the estate are going to come off first. I do want to go back and talk about taxes, because I did touch upon if estate taxes are owed, then what happens in terms of that 9 months. So estate taxes are taxes that are owed on estates for a person who dies with more than $5.85 million in their name. And that is the New York State rule. So if you die a resident of New York State, you have more than $5.85 million, then there's going to be estate taxes owed. If you die anywhere in the United States, right now the exemption for the federal taxes that will be imposed is $11.58 million per person, and that includes your lifetime gifts as well as gifts left at death. And in that case, the 11.58 million, we believe that is going to go down The law currently, as it reads, that's the case through 2025, and in 2026, it's set to sunset back down to the level that New York State is at right now. And a lot of people are talking about how with the need for increased revenue for the federal government at this point in time, it's very likely that they're going to lower that exemption sooner rather than later. Okay, next question.
Thank you. Next question. Is it possible to have an outside executor which is not beneficiary or relative?
So it is possible. The executor can be a friend. It can be someone who is a beneficiary. It could be someone who is not a beneficiary. Law firms can serve as executors so it's definitely possible to have an outside executor.
Thank you. Next question. Can you discuss if there are different rules that apply to an administrator that was set up by the trust prior to death?
So there are different rules, because if the person was appointed through a trust, then they're not an administrator, they're a trustee. And that was at the beginning, I mentioned that it's a little bit different with a trustee. While a lot of the duties and responsibilities are going to overlap with that of an administrator and executor, in that case, the duties of the trustee are actually laid out in the trust, but they will be very similar. You'll still want those receipt and releases. You'll still have to pay the debts off the top, but that's going to add a little bit of nuance that's going to be different case by case.
Thank you. Can you discuss, I apologize, I was going to make a will and have my brother an executor, but he just went on Medicaid. Is that a concern?
So the mere fact that he's on Medicaid shouldn't affect your estate in any way. I don't think that being an executor is a job. It doesn't give you the right to own anything. The question would more be your brother's ability to handle the functions necessary of him. But being on Medicaid's just health insurance, and being an executor is a job. The only question is going to be if he receives commissions as executor of your estate, depending on the type of Medicaid he's on, you just may want to deal with the fact of whether or not he should be receiving commissions, because that's earned income.
Okay, what if the estate is worth less than what it is called out in the will to be distributed? How does the executor handle?
So it depends exactly how the will's written. If the will says X amount of dollars to one person, X amount of dollars to another person, and then the rest goes to a third person, the way it reads is that those top two people who got specific dollar amounts should be paid out before what we call the residuary, the person who gets that final percentage, whether it's 100% or it's multiple people who get various different percentages. If there's not enough to fill those specific bequests of specific amounts at the top, then they'll be prorated down so that everybody receives their prorated share of the amount based on the specific bequest.
Thank you. Do you know of the company that can manage settling, closing an estate?
I'm not exactly sure what you mean by that. We do have vendors that we use. For example, if a home needs to be cleaned out and certain items need to be appraised, other items need to be given away to charity or otherwise disposed of. Some of it's just garbage, because we all collect a lot of things in our life that aren't needed after we're gone. So we certainly do have referrals, and if you contact us at info@burnerlaw.com, we can give you names of companies that we've used.
Thank you. Is there a conflict if the trustee hires the attorney that set up the trust to represent the trustee?
No, there is no inherent conflict in the attorneys that either drafted the will or were the draftsmen of the trust to represent the fiduciary in the estate. There only becomes a conflict if there is some sort of fight amongst the parties after death that would make the law firm who had drafted the documents a witness in any future disputes. then there could be an issue where the law firm needs to step back. But there is not any inherent conflict at the outset.
Thank you. Please repeat the New York State exemption amount for estate taxes.
Sure. This year it's $5.85 million. So it's actually $5 million indexed for inflation. So every year it changes. So the 5.85 million, meaning if you die with less than 5.85 million in your name, there are no New York State estate taxes. If you are over the exemption amount, New York State has what we call a cliff, which means that there's no tax, no tax, no tax. And then when you hit that amount and you fall off of the cliff, you're taxed back from $1. And so if somebody believes while they're still alive that they're in those planning stages and they might be approaching that exemption level, there's some planning that they may want to do and should speak with their attorney about doing to avoid the estate taxes.
Thank you. If my relatives will, two persons are to receive about $600,000, if the fund's assets remaining are less after taxes, what is the estate responsible for?
I think that's asking a similar question to the earlier one, which is what if there's not enough money to pay out to the beneficiaries? And that's when the different people will get a prorated share based on what's left in the estate.
Okay. Is there a statute of limitations on when a claim for debt can be made against the estate?
So in New York State, they have that 7-month creditor period. So for claims that the administrator or executor did not know about, after the 7 months, the assets can be distributed. But again, if the executor or administrator knew of a claim, they need to be proactively contacting that creditor and asking what the claim is and dealing with it, because they can have personal liability if they don't deal with that.
Thank you. Do I need to sign a receipt and release if I am the only distributee, beneficiary, and executor? The only item in the estate is a house, which is currently for sale. I have letters of testamentary in hand. Thank you.
No, you don't need to sign a receipt and release, because the only purpose of it is to hold the executor not liable in the future for any claims, and that would mean you would be suing yourself, so you don't have to do that.
Okay. What aspects of this process are to be handled by the court-appointed guardian?
So a court-appointed guardian is actually only a person that is serving while someone is alive. Once a court-appointed guardian, if it's a mental hygiene, Article 81 court-appointed guardian specifically, once the person is deceased, they have to go through a separate proceeding in the Supreme Court that appointed them to do a final account and close out the guardianship. And then at that point, the guardian hands over whatever's left of the guardianship money and guardianship estate to whoever becomes appointed as executor or administrator, so that they can then follow the terms of the will or of intestacy. I have a case right now where the guardian has been basically discharged by the court because they've done the final accounting and they've shown that everything was okay and how they handled the guardianship, but the money is just holding in the guardianship account because there's some issues on the estate side with appointing an executor. And because of that, the slowdown there, the guardian is just holding the money, waiting to turn it over once somebody's appointed as executor.
Thank you. Are you able to work in Florida?
We are not licensed in Florida, but we do have, in various parts of Florida, we have attorneys that we work with, depending on the part of Florida, on somewhat of a regular basis, because we have a lot of clients who are New York and Florida snowbirds, and they go back and forth. So we have had to deal with people in Florida quite often. I'll add, I'm thinking of one right now where a lot of clients of ours are New York residents, and they may die in New York, and most of their properties in New York, but they own a condo in Florida they went to 4 months, 5 months out of the year. And in that case, they actually have to have an executor appointed, a fiduciary appointed in both New York and in Florida, so that they can distribute that Florida property to whomever it's supposed to go to, or sell it if necessary, whatever has to be done after death. And so it actually will require 2 proceedings. So that's another job that often the fiduciary is going to have to do, is get themselves appointed in both states.
Thank you. Can beneficiary of the brokerage account collect before the state is settled?
Yes, if you are a named beneficiary, then you don't have to wait on these other issues because that you're entitled to that account. You just, when you're doing your own estate planning, want to think about if there are going to be issues, and you want to make sure that the beneficiaries you put on accounts and the beneficiaries in the will, that it all lines up properly so that everybody gets their share as you intended. But yes, a beneficiary and a brokerage can collect as soon as they have a death certificate and contact the brokerage firm.
Thank you. Is it customary for a will to be registered in court when it is created? If so, how can you search for a will in another state?
So I don't know if I would use the word customary, but there is a way that you can deposit a will at the surrogate's court in New York before, when it's drafted or when it's signed, before someone has passed away. So for example, if I'm drafting a will for myself and I'm afraid that upon my death, no one's going to know where it is, nobody's going to be able to find it, I can deposit it with the surrogate's court. And then if somebody upon my death goes and tries to file, say, an administration proceeding and saying there is no will, once they file that and put the information in, then it should become clear that my will was deposited there. Whether or not you can search in another state is hard to say. I will say that in New York, if you want to search for if a will is on file or after someone's death, if you want to search the records, you have to actually go to the surrogate's court. So I don't know, without going to each county, where you think it might exist, of any way that you could find out other than physically going there.
Thank you. If the will is registered with New York court, is the contents visible to all?
Not while the person's still alive, if they're depositing it earlier, but after your death, when your executor goes and brings in the petition for probate and files your will, then yes, it becomes a public record.
Thank you. By statute of limitation, I meant if the debt is over 7 years old. I think that was part 2 to a previous question.
Oh, right. I mean, there's a statute of limitations on creditors based on debtor-creditor law, but I don't know exactly the answer. It's going to depend on the state, and I think this may be the same person who was asking about out-of-state issues. It's going to depend on the state's debtor-creditor law, and I'd probably have to look it up to get the exact number of years.
Thank you. What happens if a beneficiary is dead? Does the money go to their descendants or heirs?
It depends on the whether or not it goes to the descendants, heirs, or lapses is going to depend on what the document says. So if the will should say one way or the other what happens. If it says, I give everything to my daughter per stirpes, and my daughter has passed before I have, then per stirpes means that her share would go to her children in equal shares. If it says my share goes to my daughter, but if she passes before me, this share shall lapse, then it gets redistributed back into the other terms of the other person's named in the will. So it's going to depend on what the document says.
Thank you. Husband and wife needing wills. Do they need 2 wills? And when one passes, is a new will needed?
So everybody needs their own will. We don't do joint wills. So yes, both would need a will. They don't necessarily need a new will when one person passes. It's just going to depend on how the original will was written and how the assets are held, and if they have any intention of changing where they want things to go as time passes on. But each person will need a separate will. Although I should say that if everything is owned jointly between 2 spouses, then very often when the first spouse dies, there's no need to probate that first will. But both should have their own will.
Thank you. My uncle died in Texas recently. Me and my siblings were to be his heirs. He married suddenly a year and a half ago at age 88. We don't think he did a will. How can we check?
I would say that you should, I'm just rereading the question. So I would say the best thing to do probably would be to hire an attorney or speak with an attorney in the county in which he lived. If you had a copy of the will, you don't think he did a will, but if so, you don't know if he had one. I would say hire an attorney and ask an attorney if they are able to check with the surrogate's court to see if there's a will. Also, very often I'm on different listservs for the state. So through the Bar Association, I'll have emails come through, you know, does anybody have a will on file for the X person's name? And that means that they've been contacted by somebody who's looking for the will of a deceased person. And so you might want to check with an attorney that's local.
Thank you. Who will pay co-op maintenance to avoid foreclosure while settling an estate?
So that's a hard one. I mean, if there's money in the estate that the person, the executor administrator has access to, they can use the funds in the estate that they have access to. But very often there's an issue where, I'll give two examples of what came up. One example is it took a long time for the administrator or the executor to be appointed, and so nobody had control over the money. So in that case, you either have you ask the co-op to be patient with you and let them know that they will be paid when the money's forthcoming. Or somebody can pay it, one of the beneficiaries or perhaps the executor, if they know the money is coming into the estate because they know what's there, they just don't have their hands on it yet, they can be paid back off the top because that was a debt of the estate. Now, I have another case where there was no money in the estate. There was only a co-op apartment, and the co-op said, we are going to bring a foreclosure action or not a foreclosure, I'm sorry. We're going to bring an action for non-payment of the maintenance against the estate if it's not paid. And so the beneficiaries who knew once it was sold that they would get their money back, they pulled together and found a way to pay the co-op maintenance.
Thank you. We have an addition to a previous question. I'll read the previous question first. Husband and wife need wills. Do they need two wills when one passes? Is a new will needed? She's asking, additionally, would a living trust be easier?
I'm going to give a lawyer answer to that, which is maybe. A trust is not necessarily the best option for everyone. It gets very specific as to whether or not a trust is going to have benefits. So what I would say is if you're having these questions, you should speak with your attorney about the pros and cons of a trust, the different types of trusts, and what benefits in your particular situation you may have. Because there are many people who come in and think they need trusts, and after we sit down, we realize that's not really necessary for them. And trusts are often more expensive to set up than wills. So people can avoid the expense because there's not a benefit to them, great. Whereas in other cases, if people come in, they don't realize that a living trust is really going to make the situation a lot easier after their death, then in that situation, there might be reason to have a living trust.
Thank you. Are wills prepared by Burner Law filed with the state?
We return original last will and testament documents to the client who signs them. So if you have your will, if you consult with us and have us prepare and execute a will with us, we return the original to you. Unless there's a specific situation where we discuss with you that it might be best to put it on file. I think I gave the example earlier, but I had a client who was concerned that upon his death, nobody would know where to look for his will. And so in his case, he went and filed it with the county in which he lived because he thought that that made the most sense for him. But we don't ourselves file them with the county.
Thank you. If the beneficiary is 18 years old, when will she be able to collect, or when her parents is 21 years or older?
So it's going to depend. 18 years old is an adult. You've reached the age of majority. And so there's no barrier based on the law that that person can't collect unless there's a barrier in the document that delays the age by which that person can collect their inheritance in part or in total.
Thank you. How can I confirm if property located in New York was part of a trust for death of brother who was a resident of Florida? The tax records list a local New York LLC as the current owner of record. If not part of trust, then separate action needed in New York?
So if you have a property, you can search the local records to see who the owner of the property is. If the owner of the property is an LLC, then you can search the New York State business records online to find out the address of the LLC. And if that LLC is members are in a trust, then the trust distributes it. If the LLC is a single member LLC and that single member is deceased, then yes, there would have to be a probate if the person has a will, or administration if the person does not have a will.
Okay, there's no additional questions at this point.
Okay, great. Well, thank you, everyone. I really appreciate you joining us today. And we look forward to talking to you again in the future. Please stay safe and speak soon. Bye.